and welcome to Monday the 25th of May. And for all of you with school children in New South Wales, welcome back to school. I certainly know I've got a couple of team members who are very excited about that, as are their beautiful kids. So welcome to Monday. Good morning, and it's delightful to have you all joining us again this morning. Welcome back to those who are regulars now. This is our 11th week of doing daily Facebook live streams to give you updates and with new information that affects, well, maybe two, but affects small to medium-sized business owners and not-for-profit organisations and their staff. So we're here to help you through these really challenging COVID-19 times. And for those who don't know me, my name's Bronwyn Pearson. I'm from Pinnacle People Solutions, and our company, good morning, Jess, welcome. Our company provides HR advice and services, support, etc. to regionally based small to medium-sized businesses and not-for-profit organisations. So please ask any questions you have as we go along. Our intention for these live streams is to cut through all of the swathes of information that's coming at you as business owners and employees during this really challenging time, as well as to cover particular topics that either we have identified as things that we really think business owners need to be aware of, or indeed questions and suggested topics that we've had come through from our audience. So we are delighted to be doing this and to be getting the information out there. We're producing fact sheets as a consequence of each of the live streams that we're doing. They're up on our website. And we are also recording these, so they're available after the event on Facebook, on our YouTube channel, in LinkedIn, and on our website. So outside of popping up any questions in the chat screen that you might have for us this morning, you can contact either myself or my phenomenal team of wonderful people anytime via Facebook, email, telephone, website, etc. I'm sure my wonderful guys are going to be putting those contact details up for you shortly. So feel free to use those. Come and have a chat with us about anything that at all that you might want to in terms of your business and your employment law and HR obligations. Thank you so much, Jess. Jess has just put those contact details up. Bless. So we always start our daily live streams with breaking news or big changes that have come into place since we were last up here talking to you. And that is, of course, since last Friday, because we've had a glorious weekend in the meantime. For those of you who are living in the Highlands part of the Northern Tablelands, as I am, very freezy weekend. But nonetheless, lovely to get cozy and warm and appreciate being able to be warm in the midst of single-digit temperatures this weekend. So certainly a time to crack out the thermals. So I hope that you're all well, enjoyed a lovely weekend. There've been a few changes that have been announced over the weekend and since Friday. First of all, much to my great excitement, for those of you who know me, you'll understand my level of ecstasy about this decision. But beauty, waxing, tanning and nail salons can begin treatments from the 1st of June. So interestingly, I found Brad Hazzard, the New South Wales Health Minister's comments really telling and somewhat amusing when he said that of all the requests that he's had as Health Minister in the last 3 months, this is the one that's topped the barrel. So it's not just me. So I'm very excited about getting back to see my local lovely ladies, small business owners who are working in this space. It's fantastic. So also from the 1st of June, 1st of June's become a big date for lots of different things in the last couple of weeks. Pubs, cafes and restaurants will be able to have up to 50 patrons from the 1st of June. They can have 10 at the moment. They will have to continue to adhere to the 1 person every 4 square metre rule. So that means some venues won't be able to do 50 people because they won't be large enough to do that with those restrictions. There won't be any mingling or standing around, so the Premier tells us. We have to be seated as a table. No more bookings won't be taken for larger than 10. So even if it's at a pub, you have to be seated at a table and have that 4 metre square space, as well as, of course, continuing with social distancing of 1.5 metres. But that's a bit exciting to know that those numbers are going up, especially for those venues. That will be a welcome relief, I'm sure. The other thing, of course, we know is that museums, galleries and libraries will be also reopening from the 1st of June, again with those 4 metre squared, 1.5 metre social distancing regulations. And in New South Wales, we're being encouraged to travel throughout the state from the 1st of June. So that's really exciting as well. Of course, opening all of these things up means that, you know, there is the potential for infections to spike in terms of COVID-19. We have to still be incredibly vigilant in terms of our hand hygiene, in terms of our social distancing, and in terms of taking very good care and concern for those that we come into contact with or avoid coming into contact with, as the case might be, who are immunocompromised, unwell or elderly. So we do have to remain incredibly vigilant around those things. So, okay, so there's a few other things that have been little flash announcements since Friday. Team sport is the next one. So what we've been told is that group huddles, team high fives and both parents cheering from the sidelines are off the cards for team sport. Moving forward as the government prepares for the return of community sport. So the federal government agency Sport Australia has released a return to sport toolkit yesterday, outlining how clubs can safely operate once activity is allowed to return. So those guidelines state that children will not be allowed to have more than 1 parent in attendance at games and training, with things, as I mentioned, like team high fives, handshaking, group meals and socialising banned. Associations at every level are also asked to appoint a COVID-19 safety coordinator to implement and oversee how the guidelines will be implemented across each club. So obviously this is incredibly important. The COVID-19 safety planning is incredibly important for all employers, and we're helping a whole range of organisations get that in place as we speak. But it will also be the case for not-for-profits, volunteer organisations, sporting organisations, etc. So watch this space and certainly get onto those Sport Australia guidelines for COVID-19 planning. Okay, so the other thing you might have also seen in the news on the weekend is that the JobKeeper expenditure, which was initially costed at 130 billion, looks like it's only going to cost between 60 and 70 billion because there was an accounting error in terms of the numbers of people that it's likely to cover. So therefore, calls to extend the JobKeeper program to more people have intensified since the government announced that that write-down of cost. Watch this space. We'll keep you informed as to any and all developments that happen with that. The other very welcome thing, particularly for regional areas, is that the Deputy Prime Minister and the Minister for Local Government have announced 537 local councils across Australia will benefit from 1.8 billion in funds from the 1st of July to help accelerate local projects and stimulate employment. So obviously local governments are going to be playing a critical role in responding to the impacts of COVID-19. And the idea of this funding boost is that it will help councils to accelerate priority projects that will employ locally and support local businesses and stimulate local economies. That's the plan. So the 1.3 of the 1.8 billion will be used to bring forward federal assistance grants to local councils. and the remaining 500 million will be a stimulus package for local roads, local community infrastructure, and a community-led recovery program. So that's incredibly important news as well. Unemployment impacts. There's been some crunching of that data, particularly over the weekend. There's obviously been ongoing commentary and data around that, but it's very interesting to look at the fact that 55% of the 600,000 jobs lost in April were held by women, even though women account for only 47% of the workforce. So it's disproportionately negatively affecting women. Almost 2/3 of the jobs lost were part-time as well. So that's interesting and concerning. Employment of people aged 15 to 24 fell by about 11%, compared with a fall of 3% for prime age workers, so those 25 to 54. Unemployment, as it has already been, but it's been accelerated by COVID-19, is a much bigger problem for youth, as is underemployment. And they're things we're going to have to be continually paying attention to at all levels of government and employment and so forth moving forward. There was a very interesting case of over the weekend of a BP worker who won after the union representing him took the case all the way to the federal court. So there was a BP refinery worker that was sacked for mocking the company's approach to bargaining over pay, and he mocked them through a popular Hitler meme. He has had a decisive win after the company took the case all the way to the full bench of the federal court. He was fired in January 2019 after he posted a video to an employee Facebook group using a popular meme format where humorous subtitles are overlaid on footage of Hitler screaming in his bunker in the 2004 film Downfall. The company, BP, fired the staff member on the basis that he had distributed material which is highly offensive and inappropriate, and defeated Mr. Tracy's initial unfair dismissal claim when the Fair Work Commission found the video was inappropriate and offensive and likened his bosses to Nazis. Mr. Tracy won his job back on appeal, with the full bench of the commission finding that the video was clearly satirical and no reasonable person would see it as making a point about BP executives acting like Nazis. The company then appealed to the full bench of the federal court, and the finding was found against BP and in favour of the staff member. Another important piece of information that employers particularly need to be aware of is that over the 4-week period to the end of April 2020, the Fair Work Commission's caseload increased by approximately 40% compared to the same period in 2019. And the most significant volume, in terms of volume terms of that increase, is in the unfair dismissal jurisdiction. The number of unfair dismissal claims applications received in April 2020 is 65% up compared to what it was in April 2019. So when we have said be careful, plan carefully, get good advice, do things that you know that you may not know but need to know how to do, is incredibly important at the moment, because those numbers are going through the roof, and there is a real desire, particularly on the part of unions at this point, to be making example of employers who are not doing the right thing, intentionally or otherwise. Okay, so one area of particular focus and sensitivity, which we've chosen today's topic as a consequence of, not the least of which there was a major court decision last Wednesday, which I mentioned last week, but I'm going to dive into in more detail today. And today's topic is, are your casual staff really casuals? Very important question, because the way in which employers have largely engaged and continue to engage casual staff has got many in hot water, and many others are sitting on a time bomb. So the question of, are your staff casual staff, really casuals, depends on a whole range of different elements, which we need to look at. The first is, how long have they worked for you? If they've worked for you for more than 12 months, or in some cases more than 6 months, and their work is ongoing, if they have, do they have a reasonable expectation that their employment with you would continue? And has their work been regular and systematic? And that definition itself has had some really interesting chewing over in the last 12 months. So they don't have to be working full-time hours. They do have to be working regularly and systematically, and how that's defined, as I said, has evolved over time. So are they covered by a modern award is the other question that I would ask you about your casuals, because if they are, there is very likely to be a casual conversion clause in that modern award that you need to abide by if they've served either 6 or 12 months of regular and systematic employment with you. So if your staff are covered by a modern award that has a casual conversion clause in it, and most of them now do as of January this year, then you have an obligation as the employer to let them know that that clause exists and to invite them to lodge a claim for conversion to permanent part-time or permanent full-time. You can refuse to do that conversion, but you've got a range of reasonableness clauses that and measures that you need to have worked through before you can do that, and you need to do it in writing. I'll get to that in a moment. Are you thinking potentially of making some of your casual staff redundant or letting them go? My advice in respect of that is think and plan very, very carefully, because if they've had over 6 or 12 months service with you, if that has been regular and systematic, if they have a reasonable expectation that employment with you would otherwise continue, then you need to treat them like any other staff members in the process of consultation and in the outcomes process in terms of positions that might be made redundant. They may not at the end of the day have an entitlement to notice of termination or to redundancy pay, being a casual staff member, but they certainly would need to be factored into consultation. They may well have an entitlement to those things if their employment hasn't actually been casual. So also, if you're thinking of letting a staff member go who is a casual staff member, either because you don't have sufficient work for them or they're not up to scratch and you want to let them go, again, plan carefully. Their tenure, whether their work has been regular and systematic, all of those things will have to factor in to how you manage this. Just because you, in your head, they're casual, on paper, in terms of their pay, they're casual, doesn't mean that you can just unilaterally dismiss them necessarily. So talk to us, get advice if you have any thoughts about doing that. Have you got performance issues with a staff member who's a casual staff member? Act now is my advice, and do so lawfully. You do need to do an appropriate performance process if you've got issues with a casual staff member who's done any length of time with you over 6 months. The other thing I say in terms of acting now is on the basis that the behaviour you walk past is the behaviour you accept. So if you've got any performance or conduct issues outstanding in your work environment, no matter what the nature of engagement of employment is, whether it's casual, whether it's part-time, whether it's full-time, whether it's fixed term, you should be acting now, because I promise you it's impacting the culture of your organisation. And by the time you find out that that's happening, it's too late. So please get in touch with us if we can help you to manage any performance or conduct issues that you have, particularly those with casual staff. So what if you've got a situation where you have had a casual staff member on the books for some time and they want to remain casual and you want them to remain casual? The answer to that question is that you still have obligations under the law. So you need to make sure that you're doing all of the right things, even if both parties want that engagement to remain casual. It may not lawfully be able to remain casual. So get in touch with us and get advice. And finally, I would ask the question, and I could have asked this up front because it's so important, Do they have an employment contract? That is incredibly important, and you might have tuned into the live stream that I did a couple of weeks, would probably be 2 weeks ago now. I don't think it was last Monday, might have been the Monday before, on employment contracts and position descriptions. Why bother? There's lots of reasons why you should bother, and why you need to have these things in place. And for casuals, you also need to have an employment contract in place. It's very important, and I'm going to explain why in just a moment, particularly considering the major case that came through last Wednesday. So essentially, to be a genuinely casual staff member, they need to not have a firm commitment in advance from you as the employer about how long they'll be employed for, or the days or hours that they will work. A casual employee also does not commit to all work that an employer might offer. So, for example, an employee who works to a roster that could change each week and can refuse or swap shifts is likely to be casual. They have no guaranteed hours of work. They usually work irregular and unsystematic hours. They don't get paid sick or annual leave, and they can end their employment without notice unless notice is required by a registered agreement, an award, or an employment contract. So casual employees, genuinely casual employees, are entitled to a higher rate of pay than equivalent full-time or part-time staff. This is called a casual loading. It's generally 25%, and it's paid in lieu of not getting benefits like personal carers leave, otherwise known as sick leave, or annual leave. They do get 2 days unpaid carers leave and 2 days unpaid compassionate leave per occasion. They do get 5 days unpaid family and domestic violence leave in a 12-month period, and they can access unpaid community services leave. So some casual employees work for one employer for a long period and become long-term casuals. Now, long-term casuals is one of the sort of criteria of casuals that is really under the microscope at the moment. So long-term casuals stay as casuals unless their employment relationship changes with their employer, where that there's a mutual agreement to provide ongoing work on an agreed pattern of ordinary days of work and hours of work. A long-term casual gets their casual entitlements regardless of how regularly they work or how long they work for. After at least 12 months of being engaged regularly by an employer on a casual basis, and if it's likely that that employment relationship is going to continue, then a casual staff member can request flexible working arrangements, and they can also take parental leave. They don't get paid leave or notice of termination, even if they work regularly for a long time. But this is potentially under threat by this most recent case. So let me talk through that for you in a moment. First of all, though, I'm going to talk more about casual conversion. So some awards, most of the modern awards now from January this year, requires employers, any of us who employ staff, to notify a casual employee that they can elect to convert to full-time or part-time employment after a set period, usually 6 or 12 months of regular and systematic employment. And it depends on the modern award as to whether it's a 6-month period or a 12-month period. Now, let me be clear about that. As employers, if you have a modern award that your staff are covered under that has a casual conversion clause in it, you are required as the employer to notify a casual employee that they can elect to convert to full-time or part-time after that 6 or 12 month period, whichever one applies in your modern award. Under that casual conversion clause, in most modern awards, casual employees are entitled to ask to change to full-time or part-time employment when they've worked a regular pattern of hours over a period of at least 12 months. In some awards, it can be 6 months. Could continue to work those hours as a full-time or part-time employee without significant changes. Employees who've been working full-time equivalent hours over 6 or 12 months can ask to change to full-time, and less than that can ask to change to part-time to work hours that are consistent with those they've been working in the last 6 to 12 months. Employers need to tell all of their casual staff about this entitlement by giving them a copy of the relevant clause of the relevant modern award. This needs to be provided within 12 months of a casual employee starting work, or 6 months if the modern award clause says 6 months. Casual employees that don't receive the clause are still entitled to request a change to full-time or part-time employment. So what's your obligation then as employers? Well, you need to ask your staff members in writing if they want to change to full-time or part-time employment. You can agree to the request if they make one, or you can refuse on reasonable grounds after you've consulted with the staff member. So you are obligated first to put in writing to let the staff member know that they are under a modern award that with a casual conversion clause in it, and that they are entitled to ask about being converted after either 6 or 12 months, depending on what the period is under that modern award clause. You can reasonably refuse the request if they make one subsequent to you letting them know that they could. But you must provide that response in writing, and you must indicate whether or not that's okay. And then if it is okay, you must put the changes in writing as well. You can only refuse a request to convert from casual to part-time or full-time at either the 6 or 12-month mark if the refusal to do so is reasonable and based on information that you have or information that you can reasonably foresee. Some of those reasonable grounds might be that your staff member doesn't work regular hours, that their job won't exist in the next 12 months, that their working hours will be significantly reduced in the next 12 months. There will be a significant change in the hours or days in the next 12 months, which cannot be accommodated within the days or hours during which the employee is available to work. Now, it's quite possible that any or all of these might be in place for you, given the impact of COVID-19, on top of the impact of drought and bushfires. If, however, you decide to refuse a request for conversion, you need to give to the employee your reasons in writing within 21 days of them making the written request. So if they make the request to you verbally, you need to say you need to put it to me in writing, and then you've got 21 days to provide a written response, which you're obligated to do. Okay. My advice to you in terms of your obligations around casual conversion is make sure you know what they are. And if you don't, talk to us, because we can make sure you know what they are pretty quickly. The other thing I'd advise you as business owners is to keep a close eye on how the additional entitlements that might be available to part-time and full-time staff could affect your business. This can be both financial, obviously, as well as the additional obligations that you need to meet as an employer. The other thing I would say in terms of the casual conversion clauses and your obligations as an employer is that if your casual staff are going to have the right to request part-time or full-time after either 6 or 12 months, then you want to make sure they're the kind of staff you want to keep in your business long-term. I mentioned before, if you've got any underperforming staff, no matter whether they're casual or not, but in this case, if they're casual, start performance management plans early and start them now. Any behavior or performance that is not up to scratch that you walk past is the behavior you're telling every one of your employees that you accept. So get in and get sorted, and talk to us if you need some advice about that. Look, managing your staff entitlements and potential conversion of casual staff to part-time or full-time employees, it's a complex process. It's not straightforward. Don't do it alone, is my advice. Get professional advice to protect your business and make sure that you're doing the right things by your staff as well as the right things by your business. So the big judgment that came down last week that I mentioned last week, and I foreshadowed I would be unpacking this morning in the context of talking about the question, are your casual staff really casuals, was the full federal court decision that came down last Wednesday that has determined that casual employees working regular and systematic hours with predictable periods of working time are likely to be considered permanent employees regardless of the payment of casual loading. So as a result of this case, and it's WorkPac Proprietary Limited versus Rosato is the name of the judgment, WorkPac has been ordered to pay the staff member, Mr. Rosato, unpaid annual leave, personal and carers leave, compassionate leave, and public holiday payments, which were owing on the basis that he was, in fact, a permanent employee of WorkPac, even though he was engaged as a casual. Now, there was another WorkPac case back in August 2018, which determined, which essentially supports the key principles. This most recent case, again, also against WorkPac, which is a contract labour provider to the mining industry, largely. That decision back in August 2019, this most recent case last Wednesday, has supported those key principles again. And in August 2019, that case determined that work which is regular, ongoing, and permanent in nature is not genuinely casual and therefore attracts entitlements such as paid annual leave. So what does this actually mean for those of us who are employers and who might have casual staff on our books? It continues to put at risk the status of 2.6 million casual employees, more than 60% of whom have been engaged for more than 6 months on a regular and systematic basis. So we're talking about a significant number of casual staff. With big job losses and unemployment rapidly increasing across COVID-19, what we would be hoping is that employers are encouraged to retain and take on casual employees, not discouraged, which arguably this outcome could potentially do. It is more than likely that, given the implications of this judgment for all employers across all industries that have casual staff, the judgment's likely to be appealed to the High Court, and we'll give you more information as that comes to hand. In the meantime, what we're going to strongly advise you is that if you are an employer who engages casuals on a regular basis, review their contracts and ensure those contracts are compliant straight away, like right now. You want to check your casual contracts to make sure that they're compliant. So with this renewed focus and the uncertainties around the nature of casual employment, any business, any of you, including myself, that are employing casual employees should be regularly reviewing and monitoring your workforce. If your casuals don't have a casual contract of employment in writing, then the law may imply a number of terms and conditions. So it's really important for you to have that contract in place. If you do have one in place, it's really important for you to review it in light of, for compliance and update in light of consideration of this most recent WorkPac case last Wednesday. We can help you minimize the risk to your business, may be exposed to in terms of back payment for both current and former employees who may have been engaged on a casual basis but instead worked on a long-term, regular or predictable basis for you. You need to make sure that if you've got any staff that are award or agreement covered, that you're meeting any casual conversion requirements. Otherwise, it may well be worthwhile considering updating to a part-time contract or a full-time contract. So talk to us. If you've got any casual staff and you have any questions whatsoever about any of this and how it might apply to you, it's incredibly important that you talk to us. Now, what happened after the first WorkPac case in August 2018 was that in December 2018, there were new Fair Work regulations that were put into place to clarify offsetting rules for casual loading payments. So employers who incorrectly classified employees as casual instead of full-time or part-time could be responsible for back paying various entitlements under the National Employment Standards following that first WorkPac case in September 18. However, what the government stepped in and did was to vary the Fair Work regulations to clarify that employers in certain circumstances may claim that an employee's casual loading payments should be offset against National Employment Standard entitlements that might be owing to the employee. And this regulation came into effect in December 2018. So now the Attorney General and the Minister for Industrial Relations, Christian Porter, has foreshadowed that the government, after last Wednesday's case, that in fact the government may actually look to legislate again in response to this, but we will let you know of any further developments in respect of that. In the meantime, this new regulation that came in December 18 in response to the August 18 first case, I applied where all of the following criteria are met. So that's where an employee is employed by their employer on a casual basis. The employee is paid a casual loading that's clearly identifiable as being an amount paid to compensate the person in lieu of entitlements that they might otherwise not be entitled to, such as annual leave. That despite being classified as a casual, the employee was in fact full-time or part-time for some or all of their employment for the purposes of the National Employment Standards. And the employee has made a claim to be paid for one or more of those entitlements that casual employees normally do not have, that they didn't receive for some or all of the time that they were incorrectly classified as a casual. So if all of these points are satisfied, an employer can make a claim to have the casual loading payments made to their staff member taken into account when working out the entitlements owing to the employee under the National Employment Standards entitlements. And that new regulation that came in on the 18th of December applies to employment periods that occurred before or that occurred on or after the 18th of December. So there is some measure of defence in there, but this most recent case only reaffirms those original case principles and brings into play some other elements as well that the federal government are looking at currently. So the answer, look, the advice to give you in respect of are your casuals really casual, is to make sure that you understand your obligations and your staff members' entitlements. Check all of your employment contracts, including and in particular for the purposes of today's topic, those for casual staff. If you don't have them, get them. Don't just get them. Make sure that their wording is protecting your business and still making sure that you are respectful of the and facilitative of the entitlements that apply to your casual staff. Put appropriately worded contracts in place. If you don't have them currently, get them in place and get them in place now. Deal with any performance or conduct issues that you have now, whether they're for casuals or whether they're for any other staff. If you've got issues you're concerned about, deal with them now, because the behaviour you walk past is the behaviour you accept. Make sure that you're meeting all your record keeping obligations. Make sure you've got robust policy and procedures in place. And if you're unsure about any or all of those things, get advice, get in touch. We're happy to sit with you and talk through the issues that you're concerned about and see what the state of play is for your business and what can be done. Usually we can get things in place really quickly. So that's it from me today. The casual employee space is a really tricky one. It's quite likely that as a small to medium-sized business owner, you don't know what you don't know. And we would advise you to get advice. We'd be very happy to help you, whether it's us or another avenue. Please get advice, because this can trip employers up without them even realizing that their foot's in a noose. So please talk to us. Thank you so much again for joining us today. It is absolutely delightful, as always, to have people joining us and appreciating that we're trying to get information out there and make it as digestible as possible. I haven't seen any questions in the chat screen this morning, but if you do have any, use all of those contact information guidelines to get in touch with us. Very happy to answer your questions at the next live stream. And to sit and talk to you about how these things might impact your business. If you've got any questions, you've got the contact details for how to get a hold of us. Tomorrow, please join us again, 9:15 here, and join our wonderful consultant psychologist, Jessica, who tomorrow will be looking at the psychology of relocation. Tips and strategies for relocating new and existing employees. So we're going to be having a look at that. There are businesses that are on the move. There are businesses who are recruiting, bringing in new staff. My recruitment topic last Thursday, which is busting the myth that you can't get talent in and staying in regional locations. Totally a myth buster, that one. Also can often involve relocation. So Jess is going to be talking about that tomorrow, new and existing staff and businesses relocating. So please join us and invite your colleagues and friends to join us also. We'd love to see you. In the meantime, please hug the people that you're allowed to. Please wave cheerily at those that you can't. Stay safe. Stay home unless you really need to be out and around. Wash your hands. Stay a metre and a half away from people when you're out of your house, and when you're in your house with visitors. And we'll really look forward to seeing you tomorrow. Thank you so much.